Czech Republic and Diag Human SE NML.
Yes, Lord Veterani.
My Lords, I appear for Diag Human SE and Mr. Joseph Stava. I appear with Mr. Riches, KC, just on the aisle side, and between us is Mr. Goodman, who's moved here for the occasion because he's going to deal with the Stockman point. And behind me is Dr. Parlett, Dr. Ketcherson, and Ms. Winsally. For the Czech Republic, Mr. Bastin, KC, Mr. Dunning, KC, Mr. Hoyle, Mr. Webster, and Ms. Ratcliffe. And I think some of us are dealing with different points and different appeals. So Mr. Dunning, for example, is dealing with the control appeal. And I'm just saying this because if somebody disappears, it's not a discourtesy. It's just that we're dealing with different appeals.
No, well, we'll leave it to the parties to decide who needs to be here at any given time. If people don't need to be here, then that's fine. That won't be treated as discourteous, and it'll be possible for them to follow remotely if they're interested enough to do so.
Thank you, my lord. Just a couple of housekeeping matters. The first one is that we don't yet have a transcript, a live transcript, but we've been told that it should be up and running within minutes. So we thought we could get started, but of course...
No, we'll start.
Yeah, and we'll keep an eye on it. The other housekeeping matters, just to make sure that the court has the 17 bundles of authorities which were delivered last week.
I haven't counted them, but there were an awful lot.
Yes, and I suppose our apologies for not getting those printed bundles a bit sooner. It wasn't because of lack of effort on everyone's part, but there are, of course, 3 appeals and 2 long judgments, and we had 16 days of hearings before the commercial court, so there is quite a bit of material to get through, and the investment treaty awards are not short, unfortunately, so some of them may easily take quite a lot of space. My lords, I wasn't planning to set out the background to the arbitration in great detail. We have done so in our admissibility and control skeletons. That's core bundle 5 and core bundle 20. We've probably done so in a bit more detail in the control skeleton. And of course, the background is also set out in the judgment of Mr. Justice Foxton. All I wanted to do before plunging into the Stockman appeal is to just give a little bit of very brief background on the breaches that were established by the tribunal. And that is because the reading that we've recommended for the court did not include those sections. In essence, the award from pages 256 to, I'll give the paragraph numbers, from paragraph 684 to paragraph 830 sets out the ways in which the tribunal found the Czech Republic had breached the fair and equitable treatment standard. And there were 3 main ways. First, the tribunal concluded that the Boyer letter in March 1992 represented a clear and manifest breach of the FET. Second, the tribunal found that the Czech Republic abusively used its sovereign powers to interfere with the commercial arbitration. And third, the tribunal found that the commercial arbitration review proceedings were riddled with due process violations of a level of gravity and affecting principles of such importance that the entire review proceedings violated the FET standards. So it's the breach of the same standard, but in 3 different ways. The detail of the most egregious conduct that the tribunal found breached the treaty is set out in some detail in our skeleton on control at paragraph 6. That's core bundle tab 20, page 2. And that conduct includes the meeting in 2009 in the office of the then Czech Prime Minister, where a senior civil servant observed that the police of the Czech state and the secret services held 1 member of the review panel by the balls, while a further one expected subsidies in exchange for an outcome favorable to the Czech Republic. And I said that meeting was in 2009. We don't need to get into the dates of the conduct, but just to flag that this may be an issue for later. But like nearly all the conduct that gives rise to the 3 sets of breaches, it took place before June 2011, but we may return to that if need be. My lords, moving on to the Stockman appeal, the effect of the Stockman appeal, if we are right, is that you would dispose of the other 2 objections on this appeal, the Stava June 2011 objection and the Diag June 2011 objection, because the effect of the Stockman appeal, if we're right, is that both of those objections would be precluded by Section 73. We have provided the court with a list of issues on the Stockman appeal. We have identified 4 issues which we propose to take in the order in which they appear on that document. The first issue is the lateness issue, which is the question whether the objection was indeed, as we contend and as the judgment found, taken late. That second and third issue are the sort of core Stockman questions. There have been various formulation of that issue proposed by the parties. I'm not sure much turns on the exact formulation that is chosen on the list of issue. It seems to us that the question that your lordships will need to consider is whether the loss of the right to object under Section 73 of the Arbitration Act applies to a party that made a late jurisdictional objection where that party did not ask the tribunal to admit that objection on the basis of justified delay, where the tribunal made no admission to this effect and on this basis, but nevertheless determined the merits of the objection. That seems to be, to us, to be the key issue on the appeal. There is also the question raised by the Czech Republic about the effect of Article 32. That was the third issue in the list of issues. And finally, the fourth issue is the common law waiver. Our plan is for Mr. Goodman to address your lordships on the first issue, and then I will come back on the second, third, and fourth issue. So unless there is anything further for me at this stage, I would sit down and hand over to Mr. Goodman.
Thank you. We'll hear from Mr. Goodman.
My lords, my lady, I'm going to address you on what's described in our skeleton as the lateness issue. And this is the point we address in section D of our skeleton. Just for your note, that's at CB tab 8, page 15. And subject to the court, I'm intending to make my submissions in 3 parts. First, to make some brief introductory remarks to explain what this particular issue is, the lateness issue, and why it matters. Second, to address you on the applicable legal principles on which you will see there is a relatively narrow dispute. And third, to identify by reference to the pleadings in the underlying BIT arbitration why we say the relevant jurisdictional objections were made late in this case. Turning then to introductory remarks, the lateness issue is a point that arises out of the Czech Republic's Respondent's notice. And for your notes, it is additional ground 3 at CB tab 11, page 9. We don't need to go there, but that's where you will find it. And if I can start just by giving you the summary of what we're arguing about under the heading of the lateness issue. The Stockman issue, which is obviously the central issue in this appeal, concerns the question of what happens, as Lord Verderame said, if a tribunal determines a late jurisdictional objection without admitting it. And that requires the court to look at the interplay between Section 73 and Section 71. But the point, Section 73 and Section 31. But the point made in additional ground 3 of the Czech Republic's Respondent's notice is that you don't even get to the Stockman issue because, so they say, they made all of the relevant jurisdictional objections in time. And we, of course, accept that if they were made in time, then none of the other issues in the Stockman appeal arise, which is why we're dealing with it first. Having given that summary, then, all I want to do by way of introduction, or further introduction, is just to identify the relevant deadline and then to identify the specific jurisdictional objections that we say were made late. And we call them in our skeleton the disputed objections, which we hope is a useful and neutral term. And as it happens, all 3 appeals concern the disputed objections. So I was going to spend just a little bit of time, maybe 5 minutes, running through what those disputed objections are. Turning then to the first of those 2 points, the deadline, this is an area of common ground. And the starting point here is that the Act, the Arbitration Act 1996, contains a specific deadline for making a jurisdictional objection. And we see that in Section 31.1. If I could ask the operator to pull up Legal Authorities, tab 55, page 3. Thank you very much. So section 31.1, an objection that the arbitral tribunal lacks substantive jurisdiction at the outset of proceedings must be raised by a party not later than the time he takes the first step in the proceedings to contest the merits of any matter in which he challenges the tribunal's jurisdiction. So that's section 31.1. Section 31.2, just to explain how this fits together, contains the deadline for the making of an objection that arises during the course of the proceedings. And it's section 31.3 that contains an escape valve, the ability for the tribunal to admit a late objection, and it's that particular subsection that Lord Verderame will be making submissions on when we come to the Stockman issue. But our deadline is in section 31.1, which is no later than the first step in the proceedings to contest the merits. And a similar deadline is contained in Article 23 of the Intertrial Rules, which, just to go there, that's at Legal Authorities, tab 56, page 2. Looking for Article 23, somebody will, page 22. And whilst we're getting there, the relevant deadline is that a jurisdiction objection has to be made in subsection 2. A plea that the arbitral tribunal does not have jurisdiction shall be raised no later than in the statement of defence. And then there's further colour on what happens where there's a counterclaim. I mentioned that rule alongside section 31.3 because it's common ground that this particular provision in the Intertrial 2010 rules was incorporated into the tribunal's terms of appointment. It's not in dispute that whichever rule you apply, whether it's Article 23 or Section 31, you end up at the same place in this case, which was the Czech Republic's counter memorial. We don't need to deal with what would have happened had these two, the Act and the Intertrial rules, pointed in different directions to a deadline, but if they had, Section 31 is a mandatory provision. And so we're looking at the counter memorial then to see whether the relevant objections were taken by the time of that document.
Sorry, Section 31 is mandatory when we're concerned with the Act because the seat of the arbitration is English. And did that happen by agreement in the terms of reference, or was it decided by the tribunal pursuant to Article 18 of the?
It was agreed. It was agreed, and I'll look round just to check, but my understanding it was in the terms of appointment. Yes, I'm getting some nods. So it was agreed by the parties after the commencement of arbitration, then incorporated into the terms of appointment. Turning then to the second introductory point, and that's to provide some brief insight into what the disputed objections, as we call them, actually are. And I hope this is going to be of use, not only for this appeal, but as I say, for the others. There are three disputed objections. The judge called them the law book transaction objection, the Karuna Trust objection, and the no control objection. And I'm going to start by unpacking what the references to the law book transaction and Karuna Trust actually mean. But of course, if my lords and my lady have picked that up in pre-reading and want to move me on, and it's not new to you, then please do so. But I was going to start.
Well, you'll explain, but it's not very clear to me what the difference between the three objections is. It all seems to have to do with the transfer of the shares held by Mr. Stava to the Karuna Trust. There may be subtle nuances, but if there are, then I haven't picked up those.
Yes, well, that's a fair summary, and certainly, as I'll show you, the judge saw this as being one process, in summary, affected by Mr. Stava in 2011, both the law book transaction, which I'll come to explain what that means, and the Karuna Trust was one process, and we'll see that in a moment. So we can start by picking this up at Annex 3 to the August judgment, and that is Core Bundle tab 23, page 96. And this is Annex 3, which contains the judge's factual findings in relation to the Karuna Trust and Lawbook transaction. And by way of reminder, whilst there is an appeal from this judgment, of course, when giving permission to appeal, the judge made clear that there was no permission to disturb the findings of fact in Annex 3. So we're stuck with paragraphs 160. And you see from paragraph 1 that two connected events, the judge says, take place. Sub 1, paragraph 1, sub 1, on the 25th of May 2011, you have Kingfish Financial, a Turks and Caicos company, establishes a Liechtenstein discretionary trust called the Karuna Trust. The trustee was a Liechtenstein entity, LNR Trust Reg, established by Dr. Abanza, Mr. Stava's personal lawyer, and Kingfish Financial, the settler entity, is owned and controlled by Mr. Stava. And 2 days later, you have the suite of 5 contracts signed relating to the sale of the shares in Diag to a company called Lawbook Limited, which was said to be indirectly owned by a company called Aram. So those events happened 2 days apart. Then the Lawbook transaction, the relevant contracts, we're not concerned with, of course, the precise details of those, but you see them summarised in paragraph 3 there, and you see the Lawbook transaction comprised of 1, a share purchase agreement between Mr. Stava and Lawbook, by which he sold his shares in Diag to Lawbook with 3 instalments for the payment of the purchase price. And you'll just note the date of the 3rd instalment there is the 31st of December 2011, and that's relevant as we will come to see. Sub 2 there we have the purchase price agreement. It's a separate agreement containing the price for the sale of the shares, and the judge notes towards the end of that paragraph that the price is effectively 100 cents on the dollar for the shares in a company whose only award was the award in this dispute. Sub 3, you have the agreement regarding conditions subsequent, which is important, provides that if the price isn't paid by that deadline of 31st of December, the SPA, share purchase agreement, and the purchase price agreement both get cancelled, and the shares are then transferred to Mr. Stava or instantaneously owned by him. So those are the first 3, and then if we can turn over the page, please, operator, you then see how the Karuna Trust features in this arrangement. You have 3 contracts there at 4, 5, or 3 agreements at 4, 5, and 6, and essentially, taking them together, there is at 4 an assignment by which Mr. Stava assigns to the trustee of the trust all of his rights arising under the 3 initial transaction documents. You have a pledge, that's at 5, by which between Lawbook Limited and the trustee, whereby Lawbook, as the buyer of the shares, pledges all of them to the trustee as security for performance of its payment obligations. And then 6, the letter of instruction, by which Lawbook, as purchaser, instructs Mr. Stava to transfer the bearer shares to the trustee. So that's the level of detail that we need for the purposes of introducing these objections. We move down then to paragraph 15 of the of Annex 2. Over the page, please, operator. And you see that on the 6th of December, Mr. Stava wrote to Lawbook referring to the non-payment of the first 2 instalments, stating that the deadline wouldn't be extended. At 17, you see that the transaction expired on the 31st of December 2011, that date again. And then you see the judge's conclusions as to what this transaction really was about in paragraphs 18 and 19. And we can skip forward to 19, where the judge says he's satisfied that Mr. Stava has been substantially truthful in his evidence that the Lawbook transaction represented an attempt to create apparent distance, that's important, between himself and Diag SE, following indications from high levels within the Czech government that this would be helpful to any attempt to resolve the disputes. Effectively, Mr. Stava's evidence was that this transaction was performative, designed to bring about a resolution of the dispute, and performative at the behest of the Czech state, and the judge accepted that evidence in paragraph 19. As it happens, we don't need to go there now, but in paragraph 7 and 9 of this judgment, post-Lawbook, there were attempts to negotiate with the Czech government, but they were simply rebuffed. Then finally, on this judgment in Annex 1, just to explain in relation to the Karuna Trust, I'm not going to cover the detail of that at all at this stage. It obviously is relevant to the control appeal, but just to say, as you've seen, it was a Liechtenstein trust. Mr. Stava was a discretionary beneficiary. he was a settlor in his own name. He was the protector of the trust, and the trust's sole asset was the shares in Diag SE. You get that from paragraph 20 of Annex 1. So that's just a very brief summary of the position there, but how that works will come up.
So have I got this right? The effect of the law book transaction was that whatever it did, 31st of December came and went without the price being paid, and the shares therefore reverted to Mr. Starr.
Yeah, well, almost, my lord. So it's certainly true that there was not a penny was paid in relation to it, because it was never intended that it would be. After the non-payment, the effect of the arrangements was that the shares were then, according to the documents, reverted to the trust. So on the 31st of December, that's the effect of the assignment of rights and the security.
Yep, okay, thank you.
The slight quirk on that, if I may just add, is that Mr. Starver retained, as you'll come to hear on probably Thursday or Friday, possession of the bearer share certificates themselves, but that's not relevant for today.
Yes, and there's an issue about the capacity in which he held them.
There is, yes. I'm not going to say anything more about that in this appeal.
There's also a register, I see, from the end of paragraph 19. Mr. Starver remained on Diag SE's register. Does that have any bearing on ownership?
Yes, it was noted by Mr. Justice Foxton, and if my lord will allow me, I'm going to resist the attempt to comment on the relevance of that to ownership, because it is all wound up in the control appeal. It's not relevant to Stockman. So those are a brief summary of what law book transaction and the Corona Trust actually is or actually are. The Czech Republic relied on those events, if I can call them that, to plead a number of jurisdictional objections in its Section 67 claim in the English courts, and we can see.
Forgive me. The Corona Trust was established. Was it in June of 2011?
The initial documents are on the 27th of May, and then it's, I think, registered in June, my lord. Yes.
And that
25th of May.
included the agreement to transfer the shares into the trust.
Well, the creation of the trust was a separate agreement. The agreements to transfer the documents in are all signed 2 days later on the 27th of May. If I could just go back to paragraph 1 of this annex, which is 2 pages prior to where we are now. Yeah, you see the timing there in that first paragraph. So 25th of May is the incorporation of the trust, and the 5 contracts that I took you through are signed 2 days later on the 27th of May. So that's the chronology. And you'll note that that paragraph 3 starts with the law book transaction comprised, and that includes all 5 of those contracts. There is all part of the law book transaction, both the sale and the trust arrangements. So then moving forwards with what the Czech Republic did in the arbitration claim in the English court, it relied on these events to plead jurisdictional objections to the BIT award. The judge gave a description or a definition of the 3 objections at paragraph 63 of his judgment. If you can pull that up, that's at CB tab 12, page 19. And these are, this is in the March judgment, just to orientate the court. And this is where the judge is describing the various jurisdiction objections which were pleaded, that's important, by the Czech Republic in the arbitration claim. And we had, at first instance, raised Section 73 objections to most of them. We see over the page the 3 that are relevant to the next 5 days are there at 7, 8, and 9. And those definitions are the judge's definitions of what was in the then amended particulars of claim. Now, as I said a moment ago, we argued effectively that all but a few of the jurisdictional objections were barred by Section 73. We were successful to a degree in relation to the Corona Trust law book and no control objections. And the judge whittled those down in the March judgment, as I will now show you. at paragraph 121 of this judgment, which is at page 43 of this document. The judge has, for the context, the judge in this section has concluded that this is the law book transaction objection only at this stage, and the judge then gets at paragraph 121 to an issue as to the scope of the objection taken and whether it was limited to breaches after June 2011 or whether it extended to all claims. He notes that the Czech Republic's position was inconsistent, but the conclusion is in sub 1 in relation to Mr. Stava. I am satisfied that the objection is limited to breaches post-dating June 2011, and in sub 2 concludes that in relation to Diag SE, the judge concludes that the law book transaction objection is not so limited. So there is that culling down of the relevant jurisdiction objections of the law book objection in paragraph 121. We see a mirror image conclusion in relation to Karuna Trust and the no control objection. That's at paragraph 122, so just over the page. And you see the judge says the issue of whether Karuna Trust and no control objections were made in respect to the period from June 11 onwards is finely balanced. I've ultimately concluded that these objections were sufficiently taken and that they're not barred by section 73(1). The key paragraph there is sub 5, where the judge says, however, the scope of those objections, that's Karuna and no control, was not advanced on any wider basis than the law book transaction. They relate to Mr. Stava, so far as claims from June 11 are concerned, and as to Diag SE status as an investor. And so those are the objections, when we come to look at the BIT record, those are the objections that we're looking for by the time of the counter memorial to see if they were in fact taken in time. My final...
Can we just go back to 63 and to the judge's definition of the objections?
Yes.
It looks from that as though the Karuna Trust objection is said to be an objection to Mr. Stava's claim, same for the law book transaction, and that the no control objection is an objection to Diag's claim. Is that not the right way of looking at it? That doesn't seem consistent with 1212.
Yeah.
Dealt with it there.
Yes, Mel, that is a quirk of this. The answer to that is the judge was interpreting the claimant's amended particulars of claim. And I'm actually, my final point on the nature of the disputed objections was just to explain how they potentially impact each of the arbitral claimants, that's Mr. Stava and Diag SE, differently. But the direct answer to your question, my lord, is that the judge did interpret these as applying or potentially applying to both claimants. So we'll see. All three. Karuna, law book and no control are all relevant to Mr. Stava. Karuna and law book are, he interprets as being relevant to, sorry, other way around, my lord. Karuna, law book and no control, all relevant to Diag SE. Karuna and law book relevant to Mr. Stava, and there may be some doubt about no control for reasons which hopefully will become obvious in the next 2 minutes. Then the final point, as I say, was just to explain how these objections potentially impact the two arbitral claimants in different ways. And I'm just so you understand why I'm doing that, it's so that when we look at the BIT record, we have front of mind the way that these points can in principle affect the position of the claimants differently. So taking Diag Human first, insofar as it's concerned, these objections go to the question of whether it can be considered an investor within the definition of that word in Article 11C of the treaty, and we see that at SB tab 22, page 2. Tab 22, sorry, rather than tab 2.
So when you say whether it can be considered an investor,
Yes.
Do you mean from a particular date or at all?
At all. So is it somebody who, is Diag SE a person who can accept the offer to arbitrate contained in the treaty?
Right.
And so we see...
But as whether it is someone who never made an investment?
No, we'll see. It's not relevant to that issue. I'll come to explain that in a moment, my lord. But I mean, the short answer to that is Diag SE was the direct holder, if I can use that word, of all of the inverted commas investments. They were investments, at least at the first stage of remove, in the company's name of the company. So there is no issue of did Diag SE hold any investment? It plainly did, and that's not a point that's disputed. So these, as I say, those three objections can only, in relation to Diag SE, can only go to the question of whether it was an investor. And that's not a point I understand is contentious, but my other friends will say otherwise. But you see that from paragraph Article 1, subparagraph 1 of the treaty, which defines the term investor. And there are three subparagraphs there, A, B, and C. A is natural persons or naturals of a contracting party. B is legal entities incorporated in, I'm summarising these, incorporated in or organised in a contracting party. And it's C that's relevant to Diag SE. And that's legal entities established under the law of any country which are directly or indirectly controlled by nationals of that contracting party. And it's that point there, directly or indirectly controlled by. And so the only question with that the law book, Karuna, and no control objections give rise to is, in respect of Diag, is whether there was sufficient control for it to fall within Article 11C.
From December 2011.
Well, from at any stage, it's.
Well, what's the position in 2010?
Oh, I see my law's point that there is no potential issue of control there because the shares haven't been.
Yeah.
Yes.
I mean, there's no question, as I understand it, but please tell me if I'm wrong. There is no question that Diag Human was an investor within the definition up to the time of the transactions you're telling us about.
Yes.
And the argument is that it ceased to be a qualifying investor as a result of those transactions, and that has consequences for its ability to arbitrate.
Yes, that's absolutely right, my lord.
Yeah, okay, thank you.
And so they go to Diag for this question of whether Diag is an investor, and obviously this clause is going to be looked at in much more detail on the no control appeal. Final point on this, though, is that my Lord Popplewell mentioned the potential way that these objections overlap, because it seems potentially that Lawbook and Karuna go to one of the claimants and no control perhaps goes to another, and that's just a reflection of the pleading. So the no control objection reflects what was a broad pleading that Diag SE wasn't controlled by Mr. Stava after this date. But if I can put it like this, Lawbook and Karuna are then effectively reasons for that. And so there is some overlap between the two, and that's perhaps slightly unhappy, but that's where we are with the definitions. So in contrast to Diag Human, and turning to Mr. Stava, the Lawbook, Karuna, and no control objections do not concern whether it is an investor, or he is an investor, I should say. They can't do, because the only requirement for a natural person is that they are in 11A a national of a contracting party, and Mr. Stava is Swiss. There was an issue about that at first instance, but that's not disturbable on appeal. So that they in principle cannot go to the question of whether Mr. Stava is an investor within the meaning of a treaty, because, as I say, for a natural person, he just has to be Swiss.
He has to be an investor in the qualifying investment.
That's the second point, my lord. Yes. So starting with, I finished investor. So these objections go to Diag. They don't go to Mr. Stava's status as an investor. Then we move to how do they potentially impact Mr. Stava's position, and the answer is the one that you gave, my lord, which is that they go to a separate question with him, which is, to use the Czech Republic's language, whether he held an investment within, they say, the meaning of the treaty. And the question, of course, of whether any requirement for an investor to hold an investment is, whether that's an issue of jurisdiction, is the question that's coming for you in the what's called the Stava June 2011 appeal. And we say it's admissibility, they say it's jurisdiction, and you'll hear about that tomorrow, I suspect.
So I think this probably isn't what you're going to be dealing with, but for those purposes, we're looking at the meaning of Article 2.1, are we? What's meant by investments by investors of the other contracting party?
There are. I can hear my team around me. I'm gonna refrain from.
Yes.
The position is that there are there are several provisions of the treaty that are potentially in play when looking at that question of whether any requirement to hold an investment is jurisdictional. And as I understand it, my lord is right that the wording of investments by is something that the Czech Republic rely on, but there
I'm
are
just flagging up. I'm speaking for myself. I am interested in what the parties say is the relevant connection between investment and investment
yes,
from those words, whether it's ownership, whether it's control.
yes,
Looking at it from the starter point of view,
yes.
not from the Diag point of view, because there seem to me to be potentially two questions that arise. What is the necessary degree of connection between investor and investment
Yes.
to fulfil Article 2.1, and then there'll be a factual issue as to whether it was fulfilled and at what time it has to be fulfilled, which is a separate question. But I hadn't myself identified, and I'm sure it's my fault,
Yes.
quite what the answer to the first question was on each party's case. I think the judge assumed it just meant ownership.
Well, my lord, I think I'm avoiding trespassing on the members of the team who are dealing
No,
with
that's
that.
fair,
If
fair
I just, all I will say is that the issue in that appeal is actually one of classification, i.e., whatever that, if there is any such connection, whatever it is it a question of jurisdiction or is it a question of admissibility? And that's all I will say about that.
I'll wait to be educated on that.
Well, thank you. So that was a hopefully useful brief tour of why the three objections affect the status of each claimant in a different way. One in respect of whether it's an investor, and one potentially in respect of whether it holds an investment, if the Czech Republic is right about that being jurisdictional. That's all I was going to say by way of introduction. Turning then to the law, the key provision relevant to the lateness.
Sorry to keep interrupting you. But so far as both Stava and Diag are concerned, what is the difference between the law book objection and the Karuna Trust objection?
We would say that they are part and parcel of one process, and in effect what the court is looking at is what the position is when they, as at 31 December 2011 or 1st of January 2012, when those contracts have sort of worked themselves through and the shares become, are according to the contracts, transferred into the trust. So picking them apart may not be very fruitful. The difference is they're obviously two different events, but they are one process. And the question for the court will be looking at the position at the beginning of the process versus at the end of the process. Does Mr. Stava retain control? But in terms of the definition, the definitional difference is, of course, that law book is referring, the law book transaction objection is referring to the 5 specific contracts. Karuna Trust is referring to the movement into trust. And I'm afraid I haven't got a better answer than the slightly unhappy definitions, that there is an overlap between the two. And I can't explain to you, my lords, a sort of clear, logical, dividing bright line. There is unfortunately some overlap because of the way these were defined, which was a reflection of the, I should say, the amended particulars of claim.
I mean, there's a point floating around somewhere, I think, that the law book transaction was something which Mr. Stava was encouraged to do by the Czech Republic. You showed us the paragraph about that,
Yes.
and that may have legal consequences. But whatever the position about that may be, that doesn't apply, does it, to the Karuna Trust point, because it was his decision, once the law book transaction didn't produce a settlement, to put all the shares into the Karuna Trust.
My lord, I understand that's a point that's made against us.
Yeah.
We say it's part of one process, and at the risk of seeming like I'm over-delegating, that's an issue for Mr. Riches on Friday, rather than me today. But there is that issue. That
No, I'm simply identifying that may be a difference between law book and Karuna Trust, whatever the merits of the point may be.
Yes.
Yeah, okay.
Yes. It may be their argument, yes.
Yeah.
Turning into the law, the key provision relevant to the lateness issue is section 73 of the Act. this is one of our rare forays in this week into English law. And can I ask the operator then to just to bring that up? It's at Legal Authorities, tab 55, page 13.
It will help actually when references are being given to the authorities. For those of us working on hard copies,
Yes.
if we are told which of the 17 volumes it's in.
Yes,
I think we've been to this one before, so we found
Yes.
that. But just as a general point, please.
Thank you, Will. Yes, I will do. I have those splits to hand. LA 55. So we are in, you may have beaten me to it, but we're in volume 8.
Yep.
This is a provision that's likely to be familiar to the courts. I'm going to very briefly take you through it and then just explain the narrow dispute on the law that exists under the heading of the lateness issue. Section 73, loss of right to object. You will see there that if a party to arbitral proceedings, and this starts with a series of deadlines, takes part or continues to take part in the proceedings without making, and here come the deadlines, either forthwith or within such time as is allowed by the arbitration agreement or the tribunal, or by any provision of this part, so a series of deadlines, any objection, A, that the tribunal lacks substantive jurisdiction, B, proceedings have been improperly conducted, C, failure to comply with the arbitration agreement or provision of this part, and D, any other irregularity affecting the tribunal or the proceedings. And the reason that this provision is relevant to the lateness issue is, of course, because what the Czech Republic contends is that it made the relevant objection that it now wishes to run in the arbitration claim by the time of its counter memorial. And so the task of the court is therefore to identify whether the three disputed objections, as we call them collectively, were made to the VIT tribunal by the time of the counter memorial. And as I said at the outset, if they were, then they were made in time. And if they were not, then they were made late, and we get into the Stockman issue. And so that raises the question of how narrowly or broadly one should interpret the word objection in section 73, which is an issue that we don't see has ever been considered by the Court of Appeal before. It arose in the Neok and Crescent Petroleum case that came before the courts last year in the context of an application for permission to appeal the court, which Lord Justice Mayles was a member of. And the court's judgment said that it didn't, although it found the arguments interesting, it didn't need to decide the point because the application for permission to appeal failed for other reasons. And so the current state of the law on that question of how narrowly or broadly you interpret the word objection is that there are perhaps 10 to 15 first instance decisions that have all accumulated principles along the way to be applied. And just to give you some archaeology, but without taking you to the cases, there was a recent attempt to pull those principles together and summarise them in one place by Mr. Justice Robin Knowles in the province of Balochistan case. I'm not going to go there, but just for your note, that's it at Legal Authorities, tab 52.1. Mr. Justice Robin Knowles collected the principles together. His collection of principles was then amended by Mr. Justice Butcher in the National Iranian Oil case. And it is that summary of principles, the Butcher J amended summary, which the judge in this case adopted in his March judgment. Can we go there, please, operator? That's at Core Bundle, tab 12, page 23. And you see first what's required to make any objection that the tribunal lacks substantive jurisdiction, and the related question of how far it's permissible for the court to elaborate on or supplement an objection which was taken before the tribunal before it becomes a new objection. And you see there that both parties referred to the summary in the National Iranian Oil Co. Neok case, and you see the judge's summary of the principles given by Mr. Justice Butcher. I was going to ask the court, rather than me read them out, just to read down from 1 to 9, if I may. those principles have led the current editors of Mustel and Boyd in a passage which isn't actually before the court, but isn't material. But the current editors say that the test is effectively a "you will know it when you see it" test as a result of those 9 principles. And just pointing out and highlighting principle 5, that the term objection has been interpreted as meaning a ground of objection. And it's usually easy to recognise or obvious in particular cases whether a party is attempting to raise a new ground. That's the "you'll know it when you see it" bit.
Have you got a page reference for Mustel and Boyd?
I will do for you today, but I'm afraid not on my feet. Someone has a copy here. There is an editor here, actually. We see, so those are the NEOC principles. They're adopted by the judge. You see that at paragraph 70, where the judge says, "I gratefully adopt that summary." And he adds 4 observations. And we'll come on to those observations in a moment. But I want to start by explaining the narrow dispute on the law that exists on this issue. Neither party contends that the judge identified the wrong principles when adopting the 9 NEOC principles. And we can see that at paragraph 57 of the Czech Republic's appeal skeleton. If we could go there, please. That's a core bundle, tab 10, page 24. And you see in paragraph 57, the final sentence, that what is said there is whether by narrowing of the test, sorry, my lord, I want to take my lords and my lady, I want to take the sentence before. Although the judge noted such points, he supplemented them with further reasons against taking a broad approach. And there's that reference to Judgement 70 with the 4 observations. And then whether by narrowing the test or by narrow application of the test, the judge erred by holding that these objections were not sufficiently taken by the point of the counter memorial. So the very narrow dispute as to the test really concerns the 4 additional observations and as to whether they narrowed the test. And our case is that the 4 observations did not narrow the tests, but even if they did, the judge was justified in so doing. And in support of that submission, I have 5 points to make, after which we will then turn to look through the record in the arbitration. The first point then is that as to the purpose of section 73, which we see identified in the DAC report, that is at Legal Authorities tab 54, which is in volume 8 of your authorities bundles. Page 4, please, operator. And this is the DAC report under clause 73, talking about the purpose of section 73. Paragraph 297, and the highlighted passage, recalcitrant parties or those who have had an award made against them often seek to delay proceedings or to avoid honouring the award by raising points on jurisdiction, etc., which they've saved up for this purpose or which they could and should have discovered at an earlier stage. And then there's some discussion of the escape clause of reasonable diligence in section 73, where a point is not taken but with reasonable diligence couldn't have been. So that first sentence we rely on as being key to looking at section 73 as the purpose. That's my first point. Second point is that there is obviously a qualitative element to the test to be applied to the meaning of the word objection. Turning back to the March judgment, please, at core bundle, tab 12, page 23. You see this qualitative element emerge in principles 7, where the substance of each ground has to be put, and at principle 9, the issue has to be distinctly put. And we would submit that some qualitative element is necessary. And we say that because one can look at how to construe the word objection, perhaps at 2 strict spectrums, both extreme. One extreme end of the spectrum is that a party has to effectively run a carbon copy of all the arguments and submissions it made in the arbitration in the court and can't depart from those at all, and that's obviously unrealistic. At the other end of the spectrum is the equally unrealistic position where all the party has to do in the arbitration is say, I object to jurisdiction, and that opens the door to whatever further points it wants to make in the court. And so it's plainly not either of those extremes, it's somewhere in the middle, which is captured by the substance test. Third point is that in our submission, and unsurprisingly, given the purpose behind section 73, 8 of the 9 principles swim in the same direction. And that general direction is effectively to ensure that the arbitration is not a futile dress rehearsal, and the court shouldn't be dealing with points, to use the DAC report's language for the first time, saved up by the parties. The outlier, and this is where we start to get to the dispute, is between the parties in this appeal, is principle 6, which is that the grounds of objection should not be examined closely as if a pleading, but broadly or adopting a broad approach. The fact that different and broader arguments are raised or new evidence is put forward doesn't mean there is a new ground. And the Czech Republic relies on this principle, principle 6, as being the dominant force behind section 73. And I want to explain why we say that principle, we don't dispute that it's there and part of the test, but we do say it has to be considered in the context of the case which it emerges from, and is explained by the specific facts of that case. So I was going to go there very briefly, and that is Prime Trade AG and EFAN Limited, 2015 EWHC 2399com, decision of Mr. Justice Akins, and that is at Legal Authorities, tab 39, which you will find in your volume 7, page 1. That's LA 39, page 1. And on the facts of this case, as you can see from the headnotes, that this was a case where the ship owners commenced arbitration against Prime Trade as a result of an explosion which led to a total loss of the vessel and total loss of the cargo. The bills of lading, which didn't name Prime Trade as a consignee, incorporated an English arbitration clause. And we can pick up the judgment at paragraph 9, page 6. You see there, owners started an arbitration claim against Prime Trade, making their claim for damages. Prime Trade retorted by saying it wasn't bound by the arbitration clause, nor could it be sued for damages. And crucial point here, because it was neither the lawful holder of the bills of lading, nor had it made a claim within the terms of section 2 and 3 of the 1992 Act. The 1992 Act is the Carriage of Goods by Sea Act, 1992. And then moving down to paragraph 12 over the page. You see that just the letter E on the right-hand side, sentence starts on the right-hand side of the page, that the owners submit that Prime Trade now wishes to run new arguments on the question of whether it was ever the lawful holder of the bills of lading, and if it was, whether rights of suit were transferred to it. To understand the difference between the old objection and the new objection, we do need to look very briefly at COGSA 1992, but I will spend as little time on that as possible and then move on. But that is at paragraph 16 of the judgment over the page. And this is where the relevant provisions of COGSA are set out. And you see at section 1, the Act applies to bills of lading. Section 2 is a provision that whereby certain rights under shipping documents are transferred to, at A, the lawful holder of a bill of lading. At section 3 over the page, you see that liabilities under shipping documents, and that's relevant because that includes the liabilities that Prime Trade are being sued for and the arbitration clause, etc. Liabilities under shipping documents are also transferred. The relevant provision is B, to a person who makes a claim under the contract. And I'm going through that relatively quickly because the key provision is really 5 here, because it's 5 that defines, particular section 5, subsection 2 defines a holder of a bill of lading, and there are 3 subsections there, A, B, and C, three ways that a person can become a holder of a bill of lading. A person with possession of the bill who is identified in the bill, in summary. B, a person who is in possession of the bill as a result of delivery, endorsement, or bearer bill, or transfer of a bearer bill. And then C is the one that I just want to focus on, which is a person with possession of the bill as a result of any transaction by virtue of which he would have become a holder falling within paragraph A or B above, had not the transaction been effected at a time when possession of the bill no longer gave a right as against the carrier to possession of the goods. There is then a fourth requirement there, that a person shall be regarded as a holder whenever they've become a holder in good faith. And the reason I linger on the definition clause is just to explain what happened in this case was that before the arbitrators, the argument was about, it seems, 5(2)(b). So that was the definition clause that was in play there. And before the court, this is my summary, before the court, the change was to seek to rely on, or the new point was to seek to rely on 5(2)(c). And the reason that there was that change is not expressly made clear, but it seems to have occurred to those arguing the case that because the goods had been lost, 5(2)(c) was the relevant provision and 5(2)(b) was not applicable at all. And we can pick up the judge's conclusions then at paragraph 54 of the judgment. That's on page 25. There's a reference again to the DAC report. The judge says, sorry, if we could go over to paragraph 60. The judge talks about what a ground of objection means, and he says, I think it's wrong to be prescriptive or to lay down precise limits in the abstract. Then if we could, yes, paragraph 60, take this case, I'm reading about halfway down paragraph 60. In my view, Prime Trade raised two grounds of objection to the arbitrator's jurisdiction. They are that Prime Trade was not a holder of the bills of lading at any relevant time, and that it did not make a claim against the owners. Therefore, it's not bound by the arbitration clause. And if we just turn over, Prime Trade raises the same two grounds of objection on this appeal. And this is the key sentence. I accept it raises different and broader arguments on the first ground, but in my view, all those arguments are within the same ground of objection to the jurisdiction of the arbitrators. The argument that no right of suit is transferred to Prime Trade, even if it became a holder of the bills under section 5(2)(c), is in my view within that first ground. And then finally to paragraph 112 of the judgment, which is on the final page. I will just get the reference. Yes, thank you. Paragraph 112.1, on the proper these are the conclusions. On the proper interpretation of section 73(1) of the Act, an appellant under section 67 is entitled to argue any point coming within the existing grounds if we turn over of objection to the jurisdiction that was raised for the arbitrators. Slightly curiously, this being the conclusion paragraph, there is then some further colour given on what that means that wasn't provided in the main body of the judgment, but there you go. The judge says the grounds of objection should not be examined closely as if a pleading, but broadly. In this case, all the arguments which the appellants wish to advance on the appeal are within the two grounds of objection to jurisdiction advanced before the arbitrators. And so we submit, and this is where principle 6 of the NEOC principles as adopted by the judge in this case comes from. And we say it's right that we don't dispute that you shouldn't look at matters as if they were English commercial court pleading, because that's a level of hyper specificity. And it's obviously right that it's more broad than that. But importantly, looking at matters broadly doesn't detract from the need to identify the substance of the point and distinctly put it. And we do say that this was a reflection of the particular facts of the case. You've seen where it was all about different definitions fundamentally within the same clause. And it would have been odd in any event for the English court to have proceeded under the wrong definition clause when the judge concluded that it was 5(2)(c) that was applicable when the goods were lost. So it was a case of the English court proceeding under the provision of COGSA that actually applied. And so this was a very narrow we would say, a very narrow shift in the objection that was run before the arbitrators to the objection that was run before the court. And that gives birth to the principle that you look at these things broadly, and we say that principle has to be examined in its context. That's all I want to say about prime trade, just so that you understand the limits of that principle and where it comes from. Fourth of my 5 points on section 73, which is that the one positive point on the law which the Czech Republic does make in its skeleton on section 73 is at paragraph 58 of its skeleton, which you see at core bundle tab 12, page 24. Yes, core bundle tab 10, page 24, very sorry. And having at paragraph 57 relied on the prime trade principle as being the sort of main driver behind section 73, whereas we would say it's not, at 58, the point is made that it's a well-established principle that the court is to adopt a broad approach. And they say it's also justified by the fundamental importance of a party who's not agreed to arbitrate being able to challenge jurisdiction, and also by the different approaches to pleading that are seen in international arbitration seated in London. And we just make this point that is to approach matters from the wrong end. It's obviously up to parties to choose whatever seat they want for their arbitration, but once they've chosen a seat, they have to comply with the minimum requirements for raising a jurisdictional objection. And we have our minimum requirements, and we would say they can't reasonably be described as too exacting. The rules are not that you have to comply with English commercial court pleading rules, but the rules are that you have to put the substance of your point and put it distinctly to the tribunal as denying jurisdiction. And so that's what we say about their paragraph 58. Final point then is the judge's observations themselves that are the potentially contentious points that the Czech Republic say narrowed the test, and they are at paragraph 70 of the March judgment at CB core bundle tab 12 page 23. These are the further observations which are, as we understand it, contentious. We don't know which ones are contentious. We're not told in the skeleton or why, but we're told that there's an objection to the fact that the judge has either misapplied the test or narrowed it with these paragraphs. Just looking at them then, paragraph 71, the judge makes the point that section 73, as we saw, is concerned not just with jurisdiction objections, but obviously, of course, objections generally as to the conduct of the arbitration, and sets out the procedure to be followed when there's other alleged irregularities. And the judge notes that where there's an objection, for example, as to the way that the tribunal are dealing with the proceedings, then the idea is supposed to be that you give the tribunal a chance to put matters right. You say to them, we think that the way you've dealt with this is unfair, potentially breaches your general duty, whatever the point is, you raise it and allow the arbitration to correct itself. And you see the reference there to Rustau trading on the top of the second page where that point was discussed. And the judge makes the point in paragraph 1 that principle, the idea that the tribunal can correct their own course, or at least consider correcting their own course, suggests that some degree of specificity is required when identifying whether an objection taken in court is the same as the one taken before the tribunal. The second point the judge makes is that there is a provision in section 32 of the Act that permits the tribunal to refer to the court questions as to the substantive jurisdiction of the tribunal. And if we just go to section 32, that's at LA Legal Authorities tab 55, which you will find in your bundle, your volumes 8. Page 4. this, section 32(1), the court may, on the application of a party to arbitral proceedings, determine any question as to the substantive jurisdiction of the tribunal. That's the only point I wanted to highlight there. If we go back to paragraph 72, which is at core bundle 12, page 24. The judge makes the point there, having quoted section 32, that if the ground of objection raised at the hearing he's referring there to the tribunal, had been the subject of a section 32 order, but the court's determination of the section 32 issue would not have engaged the issue that is now raised in the arbitration claim, then that suggests, doesn't mean automatically, but suggests that the section 67 challenge involves a new ground of jurisdiction. Perhaps there should be ground of objection, but new ground of jurisdiction. The third principle is section 30, the third observation is section 31 and section 33, contemplating the tribunal being able to extend time for late jurisdiction objections, which is obviously the point that Lord Verderame is going to address shortly. And the judge in that paragraph makes the point that that envisages also a degree of specificity, because the tribunal need to investigate why a particular late jurisdiction objection is being made late, what the justification is for that lateness. And it ought not to be the case, it says there in summary, that by letting in one jurisdiction objection, admitting a late jurisdiction objection, the floodgates are open to lots of new points that ought not to have been let through the gate. And fourth and finally, the judge refers to the due diligence requirement in section 73, which is the escape clause for jurisdiction objections that weren't made before the arbitration, but couldn't with reasonable diligence have been made before the tribunal, and says that that requirement also tells against too broad a formulation of what constitutes one ground of objection, because otherwise that provision is rendered meaningless, because it's about the loss of the right to object if you don't put your jurisdictional objections forward. So we say that all four of those objections are grounded in principle and common sense. We don't actually know which of them the Czech Republic takes issue with or why. Their skeleton doesn't help us there. We say they don't narrow the test, but if they do, they're justified in doing so. Then we invite you to approve of those additional four observations as part of the relevant test for identifying jurisdictional objections. Turning then to my final topic, which is to look at what was said in the BIT arbitration. My lord has heard from me on, my lords and my lady have heard from me on what the disputed objections are, so I hope know what to look for now, and on also on what the law is in terms of how narrowly or broadly you're looking for objections to be made. And so we turn then to what was said by the Czech Republic. We're going to start with, there are only a few documents to go through, because of course if they weren't made by the time of the counter memorial, then they were too late. And so all we're looking at, so we're looking at three documents. The first is the Czech Republic's request for bifurcation. That is dated the 7th of December 2018, and we see it in supplemental bundle tab 13, page 1. Thank you. So you see on the screen, this is the request for bifurcation. This was the first document that was filed by the Czech Republic. There wasn't an answer to the request for arbitration. So this is the first document. And what happened was the Czech Republic sought the bifurcation of the arbitration at the outset, with an initial preliminary stage dealing with preliminary objections, and then the rest to follow afterwards. And as I said a moment ago, it's not asserted by the Czech Republic that you find in this document any of the disputed objections. The reason I start here is because the counter memorial refers back to it in a footnote, and so and that is relied on. So I want to start with this document so that when we get to the footnote in the counter memorial, you know what was being relied on. So turning then over the page, please, to page 2. This is important. You see there that in section 3, this document was a summary of intended preliminary objections. The point made by the judge is this document wasn't a document in which preliminary objections were actually made. It was the document in which the Czech Republic was saying this is why we think it's a good idea to split into two phases. And then turning over the page, please, to page 3. See, again, in the first paragraph, bold section 3 on the right-hand side, three lines up. Section 3 contains a summary of the Czech Republic's intended preliminary objections. Sorry to jump around, but if we go back a page to the contents page, you see 4 preliminary objections, A to D. A, B, and C are issues of jurisdiction. Indeed, B and C are effectively expressly labelled as such. D is described claimants, and that's the relevant one that we're going to look at. Claimants have not provided sufficient evidence of standing. If we briefly go there to see what's said, it's at page 60 of the of this document. Thank you, paragraph 60, thank you very much. Paragraph 60 of the document, and you see D, claimants have not provided sufficient evidence of standing. Claimants fail to discharge their burden to prove they have standing to seek protection under the BIT is another bar to the admissibility of their claims. Then if we could turn over the page, please. And then at 61, the issue of whether or not the claimants are entitled to bring claims as injured parties requires a separate analysis from the question of whether the requirements for jurisdiction under the BIT have been met. While the latter inquiry concerns jurisdictional powers of the tribunal, claimant standing is essentially an attribute of their claims. Interestingly, as you'll hear in the Stava June 2011 appeal, they now form something of a reverse ferret on that principle. But then going over to paragraph 64, which is on the following page, there is reference here to this failure of the claimants to explain and disclose details of the trust structure underlying Mr. Stava's claim of ownership and control over Diag Human SE, which is key to determining whether both claimants in fact have standing to assert the claims in the arbitration. So they've talked about standing, they've made clear that standing is something separate to jurisdiction, and they have said here that the trust structure, claims of ownership and control are key to determining whether the claimants have standing. And to be fair to the Czech Republic, they concede in their appeal skeleton that where they took points in relation to, or where they raised issues in relation to, or even mentioned Karuna law book in this document, they did so as standing points, not as jurisdictional points. This point then is then developed in a few paragraphs that follow. So if we could turn over the page, paragraph 66, it said the scant evidence that the claimants provide only muddled the issue. And there's a complaint about what has been provided in relation to the Karuna Trust. The document cite as evidence of the trust, this is the third line down, namely Schedule A, does not list Mr. Stava as a beneficiary. There's another complaint about evidence in 67. And then just to turn over to page 68. In short, the claimants have not come close to carrying their burden to establish standing in these proceedings, a criterion that is distinct from the question of whether each claimant meets the BIT definition of investor. So that's the quite swift tour, because of time, of what was said in this document. There is some reference to the Karuna Trust, but it's expressly as a standing issue, not a jurisdictional one. We come then to the key document, and that is the counter memorial. The Czech Republic's counter memorial dated the 30th of May 2019. And we see that we start by actually turning up the Czech Republic skeleton, which is at CB 10, page 25. And just hopefully helpful for your note that in paragraph 60 of their skeleton for the Stockman appeal, we see the list of references that are relied on by the Czech Republic as showing that they did in fact make each of the 3 disputed objections against each of the claimants, arbitral claimants, Mr. Starver and Diag Human. And I'm going to very briefly run through each of those. So it may be useful just to have that to one side. Turning to the counter moral itself, you'll find that at SB tab 14, page 1. And if I could ask you to look at the structure of the document again, just looking at the table of contents over the page, you see how this document is split up. At B, statement of facts. If we could turn over the page, please, operator, to page 3. Then you see a section headed jurisdiction, and it's important to note how that's divided. So you have A, applicable legal principles and relevant chronology. And then you saw, sorry, would you mind going back one page, operator? Thank you. Foundational legal principles at 1, and then turning over the page. At B, you see additional treaty-based constraints. Then at 2, chronology of events relevant to jurisdiction. And then at B, the jurisdictional barriers to claimant's case. And it's important just to stop there. An important point to start off with is it is not contended that any of the disputed objections were made as part of any of those 4 jurisdictional barriers to claimant's case. They took 4 specific points, and it's common ground that the disputed objections were not any of those. They don't even contend, second point, that the disputed objections were referred to in the chronology of events relevant to jurisdiction, which you see at subparagraph 2, just above subheading B. Instead, what's relied on, almost exclusively, say for one paragraph reference, is points made under the heading B, additional treaty-based constraints, which is, you saw under the heading applicable legal principles. So in terms of thinking again of NEOC principle 8, were these objections, was the substance of these put, were they distinctly put? We say obviously not. You can't make an objection to jurisdiction in an applicable legal principle section of a submission and then avoid making them in your 4 specific points. And this is not about pleading styles. This was drafted by Arnold and Porter, one of the world's largest and most experienced law firms when it comes to international arbitration. Let's now look at what they rely on in this document in paragraph 60 of their skeleton argument. It is, we say, extremely scant. First, at page 103 of this document, again, this is just to orientate you. You see the heading here, additional treaty-based constraints. And they rely on the quote from Article 3 of the treaty, and in particular they rely on points 2, so Article 3.2. Just let you read that. And then when you have over the page, they rely on the quote from Article 3, subsection 3. Sorry, no, they rely on Article 4. Apologies. See there, 4.1 and 4.2. But that doesn't, by itself, obviously mean anything. That's just pointing to what the treaty says. It's not taking objection, and in fact, we would say it makes matters worse for them, not better, because having identified provisions in the treaty that define what it means to be an investor or have an investment, to then not develop objections along those lines as one of your 4 points means that we say the position is worse because it's clear they were not taken at that stage. Second point relied on is in paragraph 201 of this document, which if operator, you zoom out, it's either on this page or over the next page.
Do you say actually that the relevant treaty articles for this point would have been Article 1.1c or Article 2?
Yes. Indeed, Mel. I should say it's their case that it's Article 2, I suppose, because they're the ones that say that the holding requirement is jurisdictional. But yes, if that's their case, which is, then that's the article they ought to have relied on at this stage. Secondly, then, the second thing they rely on is in paragraph 201 of this document. They rely on the sentence turning over the page, in fact. They rely on the sentence that starts, "It stands to logic that a claimant may not assert claims in relation to someone else's investment," and they rely on the second sentence there as well, "nor can a claim for an interference by the state with an investment or right that it never acquired or that it no longer possesses on the date of the alleged violation." And what we say about that is effectively, so what? It's not being asserted there that either Diag Human was not an investor, not being asserted there that Mr. Stava did not hold an investment. It sounds there like it's still being treated as a standing or admissibility issue. And we say it's not the making of the objection, it misses the mark entirely. And of course, to be fair to the Czech Republic, I anticipate what they will say is that these things must be considered cumulatively, not individually, but I will look at them individually and then you will make your assessment of them cumulatively. The third point that is relied on in the counter-memorial, we come now, is a footnote. So they rely on footnote 460 on that same page, and they rely on the sentence, the final sentence that begins, "The ownership interests. Ownership interests in Diag Human SE remain obscure. Claimants have not provided actual evidence of the extent of this."
Where are we now?
Sorry, Milan, we're on the same page that we were on, which was page 106, and we are on that page footnote 460, which starts RLA 031.
Thank you.
And I was reading the final sentence, which is 3 lines up from the bottom. The ownership interests in Diag Human SE remain obscure. Claimants have not provided actual evidence of the extent of Mr. Stava's beneficial ownership, if any, of Diag Human SE's assets, brackets, which are held in a discretionary trust in the form of bearer shares. And just, if I may, pausing there, I may come back to this in reply if I need to, but it is a point I won't need to come back to is that there is not now and has never been any suggestion that the reasonable diligence exception might operate here, so that the Czech Republic might be able to say, well, we just didn't know enough at this stage to take any of the 3 disputed objections. And one of many reasons for that is that by this point, 2 principal reasons. First is that by this point we had disclosed the trust documents, the trust deed itself and the schedules to it, and had filed some factual evidence talking about our, by which I mean Mr. Stava's dealings with the shares in Diag SE. Don't propose to take you there, I may do in reply. Secondly, of course, that the judge has found that the law book transaction itself was something that was known to the Czech Republic from 2011. The key point, though, is really there is no suggestion before you that they didn't have what they needed to take the objection that they now take before the court.
I mean, your point really is that they develop their jurisdictional points over a number of pages, going up to the heading of merits on page 138, and there's nothing there to do with events of 2011.
Yes, that was my next point, which is that when you look at the chronology, of events relevant to jurisdiction, it ends in 1993. Obviously, 18 years before 2011. We of course do say that this is all highly speculative on the Czech Republic's part. I'm going through it, obviously because I have to, because this is all that's relied on at this stage. But the next thing they rely on, there's only 2 more references, is paragraph 54 of this document, which before we go there is not in the jurisdiction section at all. We're going back now into the merit section of the document, and that is at SB, we're in this document, sorry, page 31 of this document. and they rely on the sentence, the second sentence of paragraph 54. Mr. Starver's ownership interest is in these bearer shares is difficult to discern as it's obscured by a web of opaque structures. Claimant submissions on bifurcation brought little clarity. And you can see actually in footnote 80 there, for example, claimant stated in their answer to the bifurcation request that Mr. Starver is a beneficiary of a trust that owns the bearer shares that comprise Diag SE's assets because he's an ancestor in a linear line. So we had explained why we said Mr. Starver was a beneficiary by that point, but there's no reasonable diligence argument, as I said a moment ago. So we say obviously a reference in the factual section of this document, the non-jurisdiction section, if I can call it that, isn't sufficient. And then there is only one more reference in this document. They rely on footnote 459. I'm sorry, I'm doing this in the order that they take the points in their skeleton rather than the order that they arise in this document, but that's back at page 106 of this pleading. So we looked at footnote 460 a moment ago. Footnote 459, they rely on the reference, see also Czech Republic's request for bifurcation 3D, and that's the passage I showed you at the outset, where there is a reference to the Karuna Trust, but it's all under the heading of standing expressly not jurisdictional. And if the operator, I don't know if, I think my lord and my lady are working from hard copies, but if the operator could zoom out just so that we can see where footnote 459 is taken to, yes, it's taken to Zachary Douglas, a claim must relate to the claimant's investment. That is the totality of the references that are relied on by the Czech Republic in the counter memorial to any of the disputed objections. They do make one more point. They also seek to rely on their Redfern schedule, which came after this document, as I suppose context for or to demonstrate that what was actually in play by reference to their counter memorial. Let's just briefly go there. That's at Supplemental Bundle, tab 15, page 1. This is July 2019, so 2 months after the counter memorial. And you see there's a request for documents evidencing the names of all the current beneficiaries of the trust and any other documents accompanying or amending the Karuna Trust deed, which you can see that they've already got to already exhibit, beyond those already exhibited by the claimants. And you can see in the column relevance according to requesting party, for the first time, claimants argue that that was asked, of course, the arbitral claimants argue that Diag qualifies as an investor on the basis that, and you see our case there, I won't read it out, but there's a reference to control, and then there's a reference 4 lines up from the bottom. Claimants acknowledge that in the second half of 2011, Mr. Starver created the trust, transferred all the economic benefits, and if we could go over the page, please, operator. And it's the final sentence in that column that I want to draw your reference to, because the Czech Republic skeleton say that they took the point as being relevant to jurisdiction, but it's not quite that good for them. Sorry, it's over the page. I'm sorry, my lord and my lady. Yes, it's a combination of page. Yes, indeed, my lady has the point. So the documents are relevant to quantum, so merits, and potentially jurisdiction. Now, this is all irrelevant anyway, because the deadline was the counter memorial. That was their first step to contest the merits. But insofar as they say, look at the Redfern schedule, look to see that all these points were live because we made a request in relation to the trust, then we say not so. They were described as being relevant to quantum and potentially jurisdiction.
You didn't see it as an objection to jurisdiction. Look at your answer.
Quite, we did not. Which then takes me to my next. Those are the points I wanted to make on what's said in the arbitration. I won't show you our rejoinder. Time doesn't permit, but we didn't treat these as having been made as jurisdiction objections. We then get just to fast forward, the Czech Republic's so we filed a reply. We then got the Czech Republic's rejoinder, and it is the rejoinder where these objections were, the judge held, made for the first time. We in fact said at first instance that they weren't made anywhere, but we lost that particular debate, and we didn't get permission to appeal on it. So that is that's obviously not live. But they were made in the Czech Republic's rejoinder. We can't challenge that. But we responded to that in our rejoinder on jurisdiction, which was 6 weeks before the final hearing in this case.
We haven't got your reply, have we?
We do have our reply. I can give you the reference to that. I wasn't. I was about to take you to our rejoinder on jurisdiction, which came after, to show you how.
I wanted to look at the
Yes.
your response to the
Yes, of course, my lord.
Captain Memorial,
Yes.
which is billed as, I think it's billed as being a tab 17, but my tab 17 has a placeholder in it.
It is SB 17. It may be one of the. As I understand, it's only certain documents were printed for the court. I don't know if that was one of them. One of the documents. Yes. So only certain documents in the supplemental bundle were printed, principally those that council were then intending to take the court to. So that was not one I was going to show you. I can either we can put it up on the screen, or I can have a printed copy for you.
That's all right. You've said that the reply makes clear that it wasn't treated as a jurisdictional objection, and if issue is taken on that, then we can look
Yes.
at the reply. Otherwise, I'll take your word for that.
Thank you, my lord.
Yes,
so-
just for clarity, I think I directed, in order to try and keep the supplementary bundles within manageable size in the hard copies, that they should include documents to which council intended to take us during the hearing, and that if other documents were referred to and we need them, then hard copies could be handed up at that stage.
Yes, sorry, my lord. We it's not a document I was intending to take
No,
you to,
it's
but
not
yeah,
a criticism
of
at
course.
all. I'm just clarifying what I directed in case my lord and my lady haven't seen it, and so that everybody knows.
Of course, my lord. One dreads to think what the 17 volumes of authorities would have looked like if we'd have printed all of the documents in the core bundles and supplemental bundles as well. So
Well, that thought did occur to me.
yes, my lord. But as you say, if my learned friends want to show you something in the reply, then I'll respond to it. We then have the Czech Republic's rejoinder. Unless the court wants to see it, I wasn't going to show you the places where these objections appear, because, or the judge found they appear, because we said they weren't there. If the court wants me to, I'll take you to the rejoinder. I was going to go straight to our rejoinder on jurisdiction, so the final pleading before the final hearing, and that is at SB tab 19, page 27. And we described the respondents as having raised a new objection, which is somewhat obtuse, and we describe that as the claimants are both investors within the meaning of the BIT. And so our lords may immediately see that we weren't addressing there an argument that about holding an investment and that being a jurisdictional requirement. As I say, we said before the judge at first instance that point had never been made, but the point that we did address in section E was in relation to the claimants both being investors, and we described it as new. And you can see at 65, what we're talking about there is the respondent's case proceeding from the erroneous premise that Mr. Starver gave up his interest in 2011. And then what follows is a discussion of events in 2011.
So it's fair to say that you were alive to the point that this was a new and therefore late objection.
We described it, that is fair, my lord, yes, that is fair.
Okay, thanks.
There was not just a final document in the chronology. There was then the hearing. As Lord Verderame will explain, the hearing didn't involve any oral submissions on the question of jurisdiction. And the final document reference for you, just to draw the story to a close, is the Czech Republic's post-hearing brief, which you see at supplemental bundle 21.1 tab 2. I fear here that I'm afraid Lord Justice Popplewell will not have this in his bundle either, but hopefully the screen is in front of you, and we will get a hard copy. But what you see here, this is a post-hearing brief, and this is a chronology of relevant events. And you see June 2011 appear there as an event, and you see in the right-hand column what is being said about Mr. Stava's divestment. Both claimants lost any status as qualifying investors with investments in the Czech Republic. And then if we go over the page, please, because what I wanted to draw attention to is footnote 309. In their rejoinder on jurisdiction, the claimants asserted that this was a new objection, and you see the reference I showed you a moment ago. However, the Czech Republic had made this point as early as its request for bifurcation. So just the other side of the coin, my lord, in relation to your point, is that we said it was new, and they said, no, it's not, it's been there all along, and Lord Verderame will address you on the consequence of that momentarily. And then final point before I just give a conclusion and then pass over to...
So the tribunal would have been aware, if they managed to read all 309 footnotes, that there was a dispute about whether this was new and therefore late or not.
If they had read that footnotes, then
I think we must assume that they did.
Either actual or constructive knowledge of the footnote. Yes. So then I mentioned just before my conclusion one final point, which was the which is a pleading point. So I'll cover it very swiftly. But we, as I mentioned, pleaded at first instance that all of these objections were barred by almost all of the objections taken by the Czech Republic were barred by Section 73. Sorry, I'll just find my place in my notes. And if we look at the, so we pleaded in our defence in the arbitration claim that these were all barred by Section 73. In the reply, Czech Republic's reply, in the English courts, you see what they said about that. If we can pick up CB tab 30, page 5. This is where the Czech Republic is dealing with our complaints that these objections were barred by Section 73. And we'll start in reverse order. If we can start with paragraph 13 on that page, you see, in respect of the objection at amended particulars of claim 6, i.e. that Diag Human SE was not an investor because it wasn't controlled by Mr. Stava and hadn't been so controlled by June 2011, the claimant refers in particular to rejoinder, paras 448, 449 and 474. So it wasn't actually, the short point I'm making is it wasn't actually even pleaded that these disputed objections, insofar as they concern Mr. Stava, were taken by the time of the counter-mora. What was pleaded was a later submission by the Czech Republic, namely its rejoinder. The point is at least pleaded, or arguably pleaded, in paragraph 11. Paragraph 11 refers to amended particulars of claim 4, and that is where the Czech Republic made their complaint that Mr. Stava did not hold an investment. And there is, at least in the third line, a reference to the two paragraphs of the counter-memorial that I showed you a moment ago, paragraphs 54 and paragraph 201. So drawing all those threads together, not even pleaded that the point was taken against Mr. Stava. In the request for bifurcation mentioned as expressly, insofar as mentioned only in relation to standing, expressly not jurisdictional. Limited reference to the treaty under the applicable, and the wrong bits of the treaty under the applicable legal principles aren't good enough to make an objection. They're not putting the substance of the point to the tribunal, nor are the scant references in footnotes. There is no case of reasonable diligence that this couldn't have been done by the time of the counter-memorial, and the references to the red fern take matters no further. Unless I can assist you further, my lords and my ladies, we say that these disputed objections were not made by the relevant deadline. The counter-memorial, they were made late, and as a result, what Lord Verderame has to say on Stockman arises.
Yes, thank you very much, Mr. Cooper.
My lord, my lady, I wonder if this might be a convenient time for a break for the transcriber. Otherwise, I'm happy to continue.
No, we won't have breaks. We'll just carry on.
Right.
Thank you very much.
Yes.
I was just going to begin by giving a couple of references that have just arisen now. So one is the reference to the terms of appointment that Lord Popplewell was asking for. It's supplementary bundle tab 9 at page 11. And yes, the terms of appointment were agreed by the parties and the seat of arbitration was agreed. And then reference to Mustel and Boyd, Lord Justice Males asked for it. The passage that was being referred to is at page 564.
564, did you say?
564.
Yes, thank you.
Yes, it's paragraph 14.183.
Thank you very much.
Right, so my lords, my lady, it falls on me to address the core Stockman issue, and I was proposing to do that in 5 steps. First, I will go back to section 73 and look at the precise terms of section 73. I will then look at section 31, which on our case is critical to the interpretation of 73. Third, I will consider the position of the innocent party, and I use that language advisedly because it is the language that the DAC report uses to describe the party that has not objected within the scheme of 73. And fourth, I will deal with the Czech Republic's case on section 73(1) B, C, and D, because they're effectively trying to deploy 73 against us to neutralize our own reliance on 73(1)A. And then finally, I will look at answer trough. So beginning with section 73, it may be useful to have it on the screen. And just the 2 volumes that your lordships, my lady, will need are volumes 7 and 8. All the authorities I'm going to refer to are in those 2 volumes of the authorities.
Thank you.
So the Act is at volume 8, and it's tab 55 at page 13. And that's where we have section 73. This is, of course, a mandatory provision of the Act. And in essence, section 73 imposes a sanction, which is the loss of the right to object. And we say that it imposes that sanction in clear circumstances. We are concerned with paragraph A, because quite clearly the issue, the objection that they raised is an objection to substantive jurisdiction. But B, C, and D may somehow be in play as a result of their response. But more generally, it is useful to keep in mind that section 73 deals with all of those groups of objections because it helps understand the broad language that 73(1) uses. And it also helps understand, as I will be coming back to, the fact that there is no exact terminological correspondence between the language of 73(1) and the language of 31(3). There is no correspondence because 73(1) is dealing not just with substantive jurisdiction, but with a wider class of objections. In essence, section 73 provides that the right to object is lost in all but 4 situations. First, if the objection is made forthwith or within such time as is allowed by the arbitration agreement. I'll deal with it as one situation, although it could be 2, but it's what essentially the arbitration agreement says. Second, if the objection is made within such time as is allowed by the tribunal. Third, if the objection is made within such time as is allowed by any provision of this part. And this, as we shall see, is the bridge to section 31, to which I'll return. And fourth, if the grounds of the objection were not known and not discoverable with reasonable diligence. The Czech Republic's principal case is that they made the objection within the time permitted, and as we've seen, Mr. Goodman has addressed that objection, and the judgment is on our side on that point. There is no question about the 4th objection, the 4th situation being in play, as also Mr. Goodman has explained. So that leaves us with this 2nd and 3rd situation, with those 2 phrases, within any such time as is allowed by the tribunal, and within any such time as is allowed by any provision of this part. On our case, it is the latter phrase that matter, and that is because the paragraph A objections which are the objections that we are concerned with, objections to substantive jurisdiction, do have a provision of the Act that deals specifically with time limits for those objections. So the reference to any provision of this part is clearly a link to the paragraph A objections, which are the ones that we are principally concerned about. But even before we get into section 31.3, the language of the other phrase that might be on an alternative analysis in play is still, we submit, supportive of our case. So in other words, the phrase within any such time as allowed by the tribunal, although not as good as the language of 31.3, is still good enough for our purposes.
Can I just see if
Yes.
I've understood? So is your submission essentially that the various categories forthwith, such time as allowed by the agreement, such time as allowed by the tribunal, such time as is allowed by any provision of this part, are not genuine alternatives, only some of them can apply to subparagraph A, and that the one that applies to subparagraph A is and is only allowed by any provision of this part?
That's right, my lord, and that is because subparagraph A is the one class of objections within section 73.1 that has a provision of this part that deals with all of those general situations. And we will look as section 31 deals with the time by which the objection needs to be made, the reference to the arbitration agreement, as well as the admission.
Yes.
So that, on our case, is the clearest way of reconciling the language of 73.1 and 31 and 1 and 31.3.
So your case, as I understand it, is that the word "such time as is allowed by the arbitration agreement" cannot apply to a subsection A objection.
Well, they apply via 31.1. So it's the general language that we still get to through 31.1. But in effect, because we have a provision that is a special rule that regulates all of the time limits for objections to jurisdiction, that's where one has to look at, not least because that provision, section 31, is mandatory. Now, it doesn't create a great degree of tension because, in effect, those general categories end up tallying quite well with what section 31 does, but section 31 is more specific. However, before I get to section 30,
Does section 31.1 deal with the case where the arbitration agreement provides for a different time?
No, but that's because section 31.1 has as the mandatory time limit the first step in the proceedings. So if there is a conflict between the arbitration agreement and section 31.1, then the time limit that applies is the first step in the proceedings. This was not an issue in this case because Ancetral and 31.1 align, but there are rules that might require a different deadline, but in that case, 31.1 must apply. Shall we go straight to 31, since it's obviously a key element of the analysis. I will just briefly make the point that on the locution within any such time as is allowed by the tribunal, our position is that that test would still be good enough for us because it is still a specific enough formulation that requires the tribunal to proactively identify a time within which the objection is to be allowed. And this did not happen.
On your analysis, it's got to stop with the first memorial.
On section 31.1.
Yeah.
Yes,
If what you are saying is right, then the deadline is the one imposed by section 31.1 qualifies all of the rest of it.
that's right. That's our principal case.
Yeah.
And so there, and which
Doesn't
is what,
make any sense to me, given that arbitration is a consensual process. The idea that the parties can't themselves agree to extend the time for an objection to jurisdictions seems anathema to that principle.
but what section 31.1 is saying is that the objection lacks substantive jurisdiction must be raised by a party not later than the time it takes the first step in the proceedings to contest the merits, which in this case would have been the counter memorial. In some of the cases that I was going to go through, there was a problem because under the applicable rules, an answer to the request for arbitration was required. And so there the issue was whether the time under section 31.1 was the answer to the request for arbitration rather than the full counter-memorial. In this case, ancestral and section 31.1 are aligned. They both say first step in the merits or counter-memorial. So there's no difficulty to resolve, but I do accept that there are certain arbitral rules that may pose a problem in terms of coordination with section 31.1. But section 31.1 is mandatory, and it does say that the default position for the party that wants to object is that they must object. I mean, that's what the language that it uses, must be raised by a party, not later than the time it takes the first step in the proceedings. That's mandatory language with a clear obligation. And that's for any arbitration seated in London. I do accept that it creates some potential difficulties with certain arbitral rules. It's not a problem we need to resolve for this arbitration, because on this issue they're aligned. But there is that issue. But the language of 31.1 is clear. It is
I know
mandatory.
what you're saying right there, but just come back to section 73.
Yes.
The expression such time as is allowed by the arbitration agreement, that would encompass, would it, an arbitration agreement either in its original form and writing or any ad hoc agreement to arbitrate matters in the course of the hearing.
Yes.
And so it is your case, as my lady says, that if the parties expressly agree that an objection should be dealt with, you still say that section 73A provides a bar unless the tribunal itself has allowed time in accordance with the provision of this part under section 31, because the expression within such time as is allowed by the arbitration agreement, you say, has no operation at all in relation to subsection A. Have I understood correctly?
Well, what I'm saying is that that expression is subject to section 31.1. So there are cases where the arbitration agreement will clarify what is the first step in the proceedings, and where the arbitration agreement does that, then that language, first step in the proceedings in 31.1, will be interpreted in light of what the arbitral rules provide.
There is a degree of crossed wires here. I think the point that I put to you and the point that my lord put to you are different points from the one you're answering. You're saying with respect that there may be a difference in terms of what is the timing for the first step in the arbitration. We get that, we understand that. This is a more fundamental point. As we understand it, what you're saying is the parties themselves cannot agree to a jurisdictional objection being taken later than the counter-memorial. They cannot themselves turn around and say, we're going to vary this arbitration agreement in such a way that we will allow the other contracting party to raise a jurisdictional objection after the deadline set by section 31.1.
My lady, I understand that point, and I understand the conceptual and practical difficulty with that. It is not a point that I need to resolve for my case, but where the parties to have such an agreement, were they to agree that the objection to jurisdiction may be taken later than the first step in the proceedings, all I'm saying is that there is a problem to square with section 31.1. It is not a problem.
It's not a problem unless you're right that the only gateway in section 73 is any provision of this part, and that you have to squeeze any section 73 objection, so far as A is concerned, within that as the gateway. This illustrates that that can't be the only gateway.
It can't be possibly right. Not on the language of section 73 itself, which talks about or, and or.
Well,
which are alternatives.
Yes, but that I think poses the problem of reconciling 31.3 with the reference in 73.1 of the tribunal being empowered to allow time for another objection. Now, if we look at section 31, it has the provision, subsection 1, creating a clear obligation for a time limit by which the objections must be raised, and that's in the terms that we've seen the first step in the proceedings. then subsection 3 creates an exceptional regime, an exceptional discretion that the tribunal has for admitting late objection. Now, the reading of this provision clearly suggests that there is a clear time limit, first step in the proceedings. There is the possibility for the party that wants to raise the objection to go beyond that time limit, but that possibility has to go through the gateway, to use Lord Popplewell language of section 31.3. That party must invite a determination by the tribunal of admission of the late objection on the basis of justified delay. Now, what this scheme doesn't quite capture is the problem that has been put to me, which is some inconsistency between the arbitration agreement and the first step in the proceeding language. I understand that. It is not a problem that is fundamental to my case, because there was no such agreement here for the objection to be raised later. Here, the objections clearly needed to be raised by the counter memorial, so we are within that language of 31. The disagreement that we have is on 31.3. And what I would say about the coordination between 73.1a and 31.3, that if 73.1 were to be interpreted as creating an analytically distinct power for the tribunal to allow a late objection outside the cases of 31.3, then the reading of 31.3 becomes quite problematic, because Section 31 is one of 3 provisions in the Act dealing with jurisdiction. Section 30, general competence. Section 31, objections to substantive jurisdiction. And then Section 32 on the preliminary process. Section 31 is supposed to tell a party in clear terms how they need to raise this objection. So the universe of raising the objection should be contained within 31. And that is why our preferred case, our preferred analysis, and in our view, the clearer analysis of bringing together these 2 provisions is by creating that link between the provision of this part into 31.3. And it might simply mean that the language within any such time as is allowed by the tribunal has to be read for paragraph A objections as within any such time as is allowed by the tribunal, subject to section 31.3. So that's perhaps all that it means.
That makes a lot more sense to me than a rather convoluted analysis that it only relates to subsection A.
Yes, no, I accept that. And so there's 2 different formulations that we have in 73.1, my lady. They are, my submissions are, first, they are there because they're addressing 4 classes of objections. When we come to the objection that we are concerned with, paragraph A, we can reconcile those 2 different formulations by creating a nexus that must be established because of section 31. And so, yes, it doesn't mean that that within any such time as is allowed by the tribunal falls away. It means that it is the time allowed by the tribunal following the process in section 31.
So is this where we get to? So this is the framework for it. The objection was raised late, if Mr. Goodman is right in his submissions. It was identified as having been raised late. We've seen passages about that. The parties joined issue on whether it was late or not, see footnote 309, and the arbitrators decided it on the merits. And you say they lost the right, the Czech Republic lost the right to object because there was no express application for an extension of time, and there was no express decision by the arbitrators to extend the time for making the objection. Is that the framework that we're in?
Yes, and that framework is consistent with 73.1 as interpreted in light of section 31 in our case. The party that wants to preserve the right to raise the point later must do certain things. It is not for the tribunal to preserve their right, it is for that party. And what it must do is to raise the objection in time, and if it is late, to get the objection admitted on the basis of justified delay. They haven't done that. The tribunal determined that. And so an issue that you will have to decide is whether the determination is an admission of the objection through the back door, and we say it can't be.
So if we assume that the tribunal read all the material thoroughly and conscientiously and picked up that there was this dispute, then their thinking process, although not expressed in the award, must have been either that they decided that it was not late, i.e. they accepted the Czech Republic's position on that, or they decided that it was late, but they would nevertheless deal with it on the merits. Those are the only two possibilities, aren't they?
Well, another possibility, and I'm going to take the court through some passages, is that they decided that there was this point somehow floating around, and they wanted to determine it under what, after all, is their general competence to rule on jurisdiction. That's section 30. There is no question that a tribunal can rule on jurisdictional points that neither party has raised. And I appreciate that in commercial arbitration, there may be less of a problem because it tends not to happen, although I do have a reference to a case where that happened. But in a treaty-based arbitration, it is of course quite important for an international tribunal to go through the elements of jurisdiction, which they do routinely, to satisfy themselves that they have jurisdiction. And they will end up dealing with points that neither party has raised out of abundant caution, because they want to satisfy themselves of having jurisdiction. So what they did here was realize there was a point in play, and they thought, we're going to determine it. Doesn't mean they've admitted it, doesn't mean that they turned their minds to justified delay at any point.
Well, they may or may not have done. You assert that there hasn't been any turning of the tribunal's mind to the question as to whether there should be an extension of time. But we've seen that the point was raised. We've seen that in the award, the tribunal specifically made a reference to there not having been a timeliness objection. Now, suppose, hypothetically, that the tribunal said, well, we've got this, we can see that there's a dispute about timeliness, and having a look at it, it looks to us as though it's late. It doesn't seem to be in the counter-model. But we also note that there hasn't been a timeliness objection taken, and so we can be satisfied that any delay is justified because in the particular circumstances of this arbitration, where no point is left untaken, it must be the case that Mr. Starver and Diag think that the delay is justified, and we can proceed on the basis that if they think it's justified, we think it's justified. Now, we don't need to say anything more in the award other than that we've noted that no timeliness objection is taken. That would involve an express exercise of jurisdiction under section 31(3), wouldn't it?
On our case, it wouldn't. On our case, they would need to...
Why do you say that what they've said in the award is inconsistent with them having done that?
Well, it is inconsistent because there was no request for the objection to be admitted on the basis of justified delay. The tribunal noted that we characterized it as new without taking an objection, and they just noted that. But that note can't be assimilated to what section 31(3) would require, not least because the Czech Republic's position was it is not new.
I think your case is section 31(3) does require the tribunal to exercise a discretion if it is late to say the delay is justified. What I'm putting to you is, how do we know the tribunal haven't done that in this case?
Well, there is no sign on the face of the award other than that brief comment.
Why would they refer to timeliness at all?
Well,
Objections to timeliness at all if they hadn't turned their mind to it?
Well, there wasn't an application from the Czech Republic for late admission because the Czech Republic didn't think it was late. So in a sense, the dispute as to the lateness hadn't properly crystallized because we were not faced with an application of lateness on the basis of justified delay. There was pushback on our suggestion that this was late, and then there was no oral argument at the hearing. So the issue was somewhere in the air, but the tribunal had not been invited to admit it for purposes of the objecting party preserving its right to object later on.
But if you're right about the tribunal having the competence to go over its own jurisdiction, irrespective of whether somebody raises an objection to it or not, then why on earth do you actually need an application to admit on grounds of justified delay? The arbitral tribunal just looks at it and says, well, this point's been raised, it seems to be a live issue, there doesn't seem to be any objection to it, we're satisfied that we have got jurisdiction to deal with it, and as my lord says, almost subliminally deal with Article 31.3, Section 31.3, silently, if you like.
Well, from the point of view of the tribunal, that approach makes sense. They deal with the jurisdictional issues that have been raised properly or that are somehow floating, and they deal with all of that. But from the point of view of the objecting party, that's not good enough. They can't rely on the fact that the tribunal may want to proceed with an understandable degree of caution as to its jurisdiction as a way of securing later on their right to rerun the point. The objecting party must proceed in a certain way. They are the ones who need the late admission and the justified delay determination. The tribunal can deal with it in any event, but they need it if they want to preserve their right under 73(1), and that's our case, which is why...
Is it your case that they still need it, even if they have the express agreement of the other side that the point can be taken?
Well, if that's getting into obviously different scenario, but if they...
What's your answer?
If they'd written to us and say, can we take the point late, and we had said, fine, we will not will not contest that, then we would be in different territory.
How is Section 31.3 fulfilled in that case?
Well, I think that's on a strict reading of 31.3, even there it isn't fulfilled. I should have caveated, but I accept, and there is one case, the Serbia case, that shows it, that there may be extreme circumstances where one can perhaps conceive of an implicit admission by the tribunal without any more formal process.
But it does follow from what you're now saying about that situation, that your suggestion that you can only get over Section 73 in relation to a Section 73A challenge, if you fulfil Section 31.1, can't be right. We've identified a situation in which that's obviously not so.
Well, I'll try to sort of rephrase the position. I think on the pure reading of those provisions, an admission by the tribunal on the basis of a justified delay consideration will always be necessary. There are situations at the limits where the circumstances are such where one might take the view that even absent that formal process and express determination, there has been something that can be assimilated to that process. But what I would say about these extreme circumstances is that the bar is quite high and much higher than what we have here. It may perhaps be something like the Serbia case or the scenario that Lord Justice Popplewell is putting to me, but I think it's a very high bar.
Isn't a simpler reading of the Act simply that the alternatives in Section 73 are true alternatives, and if it has been, if it is within the arbitration agreement, because it's been agreed between the parties, that's good enough.
Which is not the exception we're dealing with, but if there had been a time allowed by the tribunal, we say we prevail even on that test because the tribunal did not allow a time by which this objection could have been put. So what happened isn't good enough for that. But of course, for our case,
would you say allowed means allowed in accordance with Section 31.3?
Yes.
But perhaps one simply looking at, when one's looking at Section 73, at allowed meaning in fact allowed. Now there'll be other remedies under Section 68 if there's misconduct in them allowing it, or if they shouldn't have allowed it, but of course none of those objections are available in this case. Why doesn't allowed simply mean it has in fact, the tribunal have in fact allowed it to be taken at the time when it was taken?
The difficulty with that, my lord, is that any point that the tribunal ends up determining could be considered as having been somehow allowed by the tribunal. And that would widen the scope of what can be rerun. If, for example, we go to the award, at 2 paragraphs of the award, that supplementary bundle tab 23, if we go to page 126, paragraph 414. So here the tribunal says, as regards the respondent's argument raised in the request but not reiterated thereafter, the claimant lacks standing, it is equally dismissed. Are we to read this sentence as the tribunal allowing that objection? In our case, that's not what it is doing. It is saying a point was foreshadowed in the request for bifurcation, as we've seen, and we've seen that even the Czech Republic wouldn't characterize the points foreshadowed in their request for arbitration as points raised. It is saying a point was foreshadowed, it was not pursued, but we'll decide it anyway, because we don't want to leave anything unresolved. But when tribunals do this, and they do this very regularly in this kind of arbitration, they're not allowed the objection, they're just dealing with a point. But what the party that wants to rerun the argument before this court needs to do is to get over a more difficult hurdle. Of course, the tribunal can deal with it in this way. And if we go back to a different passage.
Yes. Where, I'm sorry, because I can't get this in hard copy, but where's the passage that makes reference to there being no objection to timeliness?
I'll take your lordship to that in a second.
That, as it seems to me, is what one needs to look at to see whether that involves.
Yes, that it's in the
allowing
summary.
the objection.
That's paragraph 310,
Thank you.
and that's at page 101 of the award.
Someone put that up for me. I don't think I've got that in hard copy, have I?
Yes, page, there should be in hard copy in the supplementary bundle 23.
Yep.
It's page 101. So that was the reference to the timeliness, which of course we understand it is a point against us, and had the tribunal not said that, our position would unquestionably be clearer. But we say the tribunal saying this isn't good enough for the other side, because they are the ones who need to get over this hurdle. It isn't us. They are the ones who need to demonstrate certain things, and they can't even demonstrate the fact that they thought this objection was new, because they treated it as not new. So they didn't request late admission because they thought it was an old objection. So they didn't even put this issue of lateness or let alone justify delay into play. And the tribunal doesn't want to spend time on it because, as we saw in the previous paragraph, they just want to deal with every point that is in play. The other paragraph in the award to which I was going to take your lordships briefly is, first of all, at page 122, it is worth noting that the heading of objection number 5 is whether claimants can be deemed investors of the other contracting party. I mean, that's a reference to what Mr. Goodman was saying about the kind of objection that was raised. This is how objection 5 is described. So when they later on at paragraph 415 deal with standing and say there was raised in the request for there was made in the request for arbitration but not reiterated, they're dealing seemingly with a different point. At paragraph 379, which is page 118, the tribunal says the tribunal considers that claimants have successfully established that at the time of the challenge measures they had an investment in Czechoslovakia. They're dealing with the objection as to the existence of the investment. It is always for the investor to demonstrate that they've made an investment. Even if no jurisdictional objection to the existence of an investment is taken, a tribunal will have to make a determination like the one we see in paragraph 379. Our case below was that the objection to the existence of the investments hadn't been properly raised. We lost on that point, and there was no permission to appeal on 73, but we then had trial on that point and we won, and there was no permission to appeal to the other side on the substance. So that point is finished. But this is just to explain that if we take an approach that says anything that is decided by the tribunal is somehow allowed or even admitted under 31.3, all of these points could be relitigated, regardless of whether the party that benefits from relitigating can demonstrate that they raised them within the time limit or within a proper process of admission. And that's our case. And that explains why we're not taking aim at the tribunal, because we don't think there was an irregularity on the part of the tribunal. The tribunal has its general competence to determine, to rule on its jurisdiction. That's what it is doing. We don't see any irregularity. There might have been an irregularity. On our case, there isn't, because they can't admit an objection and rescue the objecting party's right to rerun the point in this way. They have to be clear about admitting an objection. But if we're wrong on that, and we are indeed suggesting that tribunals can exercise their discretion under section 31.3, not as section 31.3 appears to suggest, but far more implicitly, then there might be a host of situations where another the party or potentially both parties would have to consider a section 68 objection, because they don't know if the objection was admitted with the effect of the other side having still the right to rerun it or not. But our analysis is quite clear. If you want to rerun the point, you need to demonstrate that you've done certain things. If you haven't done it, you can't just take cover behind the tribunal's analysis. You need more than that if you want to rerun the point. And on the point, the tribunal's comment on lateness, we say even that is not good enough. It is something. I have to accept that it is something for the Czech Republic's case, but it is not good enough on the analysis of these provisions that we are putting forward. The other reference I wanted to give my lord and my lady is to the Webster commentary. That's L59, LA59. It's tab 59, page 2. Now, this is not a authority which is printed, but it should be on Opus. And this is simply to make the point that the footnote here, if we go to the footnote, refers to a case where the tribunal raised a jurisdictional issue ex officio. There are different Latin locutions that one can use to describe that power, motu proprio, ex officio, but it all comes down to the same point, that tribunals very seldom in commercial arbitration will determine jurisdiction without either side having raised a point. But in an investment treaty arbitration, they will go through the motions of satisfying themselves that they have jurisdiction in a rather more formal way. But the analysis...
Sorry, I'm a bit long. We're looking at tab 59, is it, of the authorities?
59, page 2.
I don't seem to have that.
No, it's not printed, I'm afraid.
Oh, okay.
It's only on Opus. This is one of those where we didn't originally think we needed to take you, but it's the reference on the screen, which is the Webster commentary on the ancestral rules. And so to
In practice, it's for the parties to raise issues of jurisdiction, not the tribunal. That's the principle.
in practice, but I think the
See how that helps you, really.
well, no, I'm looking at that case. The tribunal raised the issue ex officio and ruled that it did not have jurisdiction, and it's that paragraph from the Larson case in footnote 1 from 5. But it is certainly true that in practice, in most arbitrations, it is for the parties to raise jurisdictional objections. But it doesn't follow from that the general competence in section 30 of the Act can only be exercised if there is a party trigger. The tribunal can rule on its own jurisdiction. And there will be cases, as I said, rare perhaps in a commercial arbitration, but in other types of arbitration, perhaps less so, where the tribunals will deal with a point that hasn't been raised because they think it is important to do so. Now here we are in a different situation because the point was raised, but it was raised late. But there's a difference between a tribunal dealing with a point raised on time, with a point that they've admitted, and a tribunal dealing with a point that was foreshadowed but not pursued, that wasn't raised, or that was raised late but not admitted. All of those scenarios, from the point of view of the objecting party, on our case, are different. Right. Now, my third point is going to be on the position of the innocent party. And that is simply to say that Section 73 does not, or Section 31(3), does not place any obligation on the other party, the party that is faced with a late objection. Both Section 31(3) and Section 73 are addressing the late objector. And they do not suggest that the party that might benefit from the failure to make the objection on time has any obligations in that situation. And the passage of the DAC report to which I was going to take you is at LA 54(4). It's just what the DAC report says. On their understanding of how this provision was meant to rule. The intent was to make it difficult for recalcitrant parties to keep running points and not to put the burden to the innocent party. We have also said in our skeleton that our analysis of the position of the innocent party accords with general principles in litigation in this jurisdiction. There is no general requirement for a party to point out another party's mistake, and we refer to the law assumption judgment in Barton and the application by this court in the context of service.
Can I just take you back to the paragraph 297 of the DAC report? Which of these objectives do you say is being achieved by what the Czech Republic has done in relation to this case? It's not a case of them seeking to delay proceedings by not taking a point early enough, or to avoid honouring the award by raising points of jurisdiction, which they've saved up. If one just looks at the overall purpose of Section 73 as identified here, what is it about the Czech Republic's behaviour that offends against the purpose of?
Well, we would say it's about causing delay and putting us through the trouble of having to relitigate a point that was raised late. So we would say it would come within this objective, in a sense, by trying to put a point that they thought had been put before.
They have raised it before the tribunal, but so they're not saving it up for a jurisdiction challenging court later. They haven't caused any delay or additional expense by raising it in front of the tribunal. You say that it's contrary to the purposes of Section 73 that they didn't, even though you had no objection to it being dealt with by the tribunal, say to the tribunal, oh, by the way, you can see they've got no objection, but please will you make a formal ruling under Section 31(3)?
Or if we're wrong and we're late, which we don't think we are, please could you extend the time?
How does their failure to do that invoke any of the things at which the DAC report suggests Section 73 is aimed?
Well, as I said, my lord, our answer would be about raising a point not within the time that was prescribed, trying essentially their luck to have a pretty substantial point that involved, as we have seen, a lot of Liechtenstein law decided in the arbitration. This was a very big arbitration. The point is raised a few weeks before the hearing in their rejoinder. And understandably, we concentrate on all of the other points that are in play, but they have their determination by the tribunal. So in a sense, they've been lucky because
Trying their luck at all. They've raised it in
Well-
front of the tribunal. And if it is jurisdictional, they're entitled to have another go later. They're not trying their luck at all. What I think you have to say is they're trying their luck by not saying to the tribunal, well, there isn't any objection to you dealing with this, but we need to get you to extend time.
yes, no, that's right.
Why are they trying their luck on that when you haven't taken the objection?
But it isn't for us.
An odd expression to use.
Yes, but it isn't for us to run that point before the tribunal is, because this is a point that arises before this court. Whether they've lost the right to object or not in these proceedings is a point that arises here. So in the context of those proceedings,
It rises before the tribunal. If you're right that they needed extra time to raise it and they weren't going to be granted it, wouldn't it arise before the tribunal?
well, it would have arisen before the tribunal, but the burden was on them to raise it so that they could rescue or preserve their right to object. We simply don't take the view that it is for us to take a step that ultimately is necessary to them to preserve their right.
Thank you.
I mean, that's my lord, our reading of the provisions. And in terms of the objectives, it accords with those objectives because they set a specific way in which objections need to be taken. I was going to move to another area that I think may require a bit of time, but perhaps just this might be a good time to break. Unless the court wants me to say anything else on the Barton principles and why we say they apply here, not directly, obviously, but the idea that a party could lose an entire claim as a result of failing because the other side hasn't pointed out an error seems to us to be the sort of situation that is even more extreme. And if that is conceivable within fair litigation, we say it is also conceivable within this kind of litigation, that it wasn't really for us to start writing to them and say, please, please put in a proper application, otherwise you can't run the point again later, or if you don't, we will say that later. So that's all our reliance on those principles. I don't think I need to develop that submission.
All right, well, we'll rise now until 2 o'clock.
Thank you.
So advising people.